we're talking about the DMV and the driver's license and the driver's license person and the DMV form. So if you go up to the link for today, I believe, you're going to see two documents. And the first one that I would send off is the question, okay? And like I said, typically I do 3 questions just to kind of line them up. But, you know, you have the same type of setup that we had on the document format. You can put from and to, although it's not done exactly like that, but that's because, you know, we've already shown that. But you write to whoever is the director of the Department of Motor Vehicles. Find it out. You can probably Google it. And within your state, if you can't Google it, if you go down to any DMV, they'll know. They have that information readily available. So, and it just says something simple like, "Greetings, John. I believe you are the man who sometimes acts as Director of Department of Motor Vehicles. Is man required to have a license to move from point A to point B?" And that's real point blank and candid. As soon as you get an answer with a signature on it, you know, that's basically all you're going to need to drive around. And I can guarantee you the director of the Department of Motor Vehicles in every state knows that it's a right and not a privilege, and they know how the system works. So I've never seen one come back and say, no, that you don't have a right. You have to have a license for that privilege. And once you get something saying, you know, from a man in an authoritative position who's representing the sovereignty of the state to the Department of Motor Vehicles to recognize that you have a right, you could write them something quite as simple as this. You know, you would have your identification number at the top, the date, you know, to, from, and you put "Greetings, John." And this is just an example. We definitely encourage people to come up with their own means of wording and speaking for yourself, because that's how you actually get to the point of conceptualizing ideas, is when you can think of your own words and put them down and be very poetic with it. So, "I, man," and then in parentheses, your full name, "hereby rescind my signature from any form or agreement in regards to the driver's license. Should you require your property be returned, I am happy to return said property, driver's license. Thank you, kind regards." Like, just as a courtesy, we're always saying thank you, God bless you, great job at your public service, only sometimes. So, was there anything else that you wanted to add to that, Shaman?
Yeah, I had a buddy. He's probably on the call right now, but we have an issue going on here in our local area, and we have an issue going on, and there was an audio recording of a meeting at the in a public forum where public notice was given by myself and a couple other guys, and just a plethora of information was delivered. And this information, basically, when presented in the proper manner, is going to show that these people flat out lied and reversed the decision. And it had to do with the municipality and some other issues. And, you know, he was going about it different ways. He called down there 2 or 3 times. I think he went down there once or twice. And he couldn't get them to respond. They just would not respond to him whatsoever. And it had been, you know, a couple, 3 weeks, and I kept wondering what was going on. So I called him up one day. I'm like, "Hey, did you forget to go to?" He's like, "No, man, I've been trying. I can't get him to answer." And I said, "Well, hold on a second. I'll write you out something, and then just write it in your own handwriting, or you make it really similar to this, and mail it to him in the mail. You want to have it on paper." And so, you know, I went ahead and text messaged him the letter, and he wrote it. If my facts are correct, he sent that on a Friday at about 11, and Monday morning they called him and said, I mean, this is like 6 weeks he tried to get this audio recording. And they called him Monday morning at about 8 or 9 o'clock and said, "Hey, come on down here and get this audio recording." So that's the difference in writing. If you know how to write and your punctuations are proper and you know how to stylize your letters or your documents, people that are in higher up positions like directors of public safety or directors of DMV, police chiefs on a small level, city attorneys, just all these people, when you write them in a certain way, they know they have a duty and an obligation to respond to their fellow man. And when you write a man-to-man, they will respond. I mean, I would say at least 95% of the time, they're going to respond to you, and they're usually going to do it within 72 hours. You got JC?
Actually, can you give me a minute?
Yeah, I can. A lot of people will write, let's say they write an attorney, or they write a prosecutor, or they write a police chief, sometimes even a judge, and they're like, man, I can't get these people to respond. They just ignore me. Nothing's happening. I don't understand why. They get frustrated. Sometimes they think they're doing wrong. They'll accuse the other side of being dishonorable. Why don't they answer? Why don't they answer? They're a public servant. They have to answer. In reality, there could be a couple of things going on. First, no response is a response. When there's a duty to respond, you're going to get, they may not respond because it's like a no-brainer, like there's no need to respond. Or it could be that they're actually committing a crime and they don't respond because they have a right to not self-incriminate. So they don't respond to you because they don't wish to incriminate themselves any further, and anything they put on a piece of paper is going to incriminate them. And the other thing, and the biggest thing is, if you're writing a police chief, a prosecutor, a judge, this is a dead fiction. You're writing nothing, and nothing doesn't have to respond to you. So if you're writing Judge Jimmy John Jacob, that letter is going into air. It doesn't mean anything. He does not have that person doesn't have any duty to respond to you, especially if you're a man or a woman writing a person. I mean, even in their world, person to person, he doesn't really even have a duty to respond because you're his property. But if a man's writing a pine cone or a dead fiction or something that doesn't even exist, how could you expect a response? So if you look at the letters that were posted up on the website, you'll notice that he's being called out as a man. You're recognizing, like you'll notice the Y and the U is capitalized because you're literally recognizing a title and liability when you say you. I believe you are the man who acts as. Now you've recognized him as man, and you've acknowledged that there's a title where he has duties, obligations. So now you've got him both on the legal side and you've got him on the man side of now he has a duty to respond to his fellow man. And that's why I say most of the time they're going to respond to you. You back?
Yeah, I'm back. So, and there are a few exceptions, like when they're committing a crime, obviously. And he's 100% correct. If you're writing one person to judge, not only do they not have a duty to respond to you, but they actually have a duty not to respond to you. And what they say is that there's a conflict of interest, and that's all kind of BS. I was actually in a courthouse one time, and I was meeting with the high clerk of that courthouse, and I asked her very, very candidly multiple times when an attorney's privilege started trumping a man's rights, and she never ever denied that was going on, and I gave her multiple chances. And it's not that really does go on. That's just a really special courthouse.
Yes, it is.
But on the other side of things, the main point is to stop trying to use the agencies and start informing them of what your wishes are, what your intents are, and do it in a nice, courteous way. And don't take up their time. They're busy people. I'm sure it takes a lot of energy and effort to run the Department of Motor Vehicles for a state every day on a day-to-day basis. So, and what we're showing you with the Department of Motor Vehicles, that will work for a lot of different stuff as well. And that whole thought process, that whole line of thought is very, very good to use when dealing with corporations, banking entities, and the like.
And here's something to think about. Like when you use words, words are very important, guys. If you write somebody and you say, I want you to do this, and I need you to give me this, this, and that, and I need this, and I need that, and then I want you to, what you've just done is beg somebody to do something. You're wanting or you're needy. You know, that lesson's an English book, the Webster's, and then understanding the definitions of words, what they really mean, their applications. It's so, so important. You know, a lot of people have the right heart, but they are so tied up in misinformation or
legalese and
like
Latin.
You think you understand what you're seeing on that paper, and we've gone over it before, and we'll go over it 100 times if we have to, but literally most of these documents you get from these courts, they open with a full all-cap, bold court name, and then it is so ordered will be in all bold, all caps. Guys, there's nothing there. That means those words are literally not even on the page. There's no such thing as an all-capital word in the English language. It isn't there. And if you read that stuff and believe it's real, because you're going to act out the part of the defendant at that point. So when you learn how to really write these people and you learn that one sentence is better than 2 paragraphs, and you're saying so much more with like 3 words than you ever could with a book, oh, man, you talk about rocking and rolling, feeling empowered and just getting results and starting to see things shift, watching other people get nervous about you instead of you always being nervous about them. And, yes, it absolutely happens, man.
In fact, I have 2 stories that actually happened within the past 48 hours, kind of dealing with that exact same situation. And one was this woman got a document in the mail today that upset her. It upset her a lot. But we were talking, and she said, you know, if this would have happened a year ago, then she would have been really upset and would have kept to herself, and she would have been scared. You know, she would have been afraid, and now she's not. You know, like she's upset that this man did something incredibly stupid, but she's not worried. She's not afraid. And I think that that's incredibly powerful. And the other woman that I was talking to, like, she actually wrote a pretty good document, writing on her own and coming up with her own words. And she wrote this really good document, and she sent it over for me to see. And I was like, okay, well, you see this here, you kind of mentioned this 3 times. So why don't you rewrite it and work this mentioning it 3 times down to mentioning it once, and, you know, get it shorter, get at least under a page. And she was like, oh, and I'm like, look, this is an emotional document. And she goes, no, it's just showing that I'm irritated and being sarcastic. And I was like, did you just hear what you said? AKA, it's an emotional document. And when you first start writing these documents, really to get the emotion out of it and to try and get the emotion out of it, the first document is always going to be emotional. Write the first document, get the emotions out, and come back to it an hour and a half, 2 hours later with a fresh pair of eyes and read it over again and just think about how you would interpret it. Remember, when you're writing these people, you are not writing it for you to write it. You're writing it for them to read it. Like, keep that in mind, that that's the purpose of how they read it and how they interpret it.
Hey, JC, I just had a thought. Can I get it out before I forget it?
Yeah.
Okay, that document, guys, that was written up on the site there for the DMV guy, okay? Okay, we've been getting a lot of questions like this about civil asset forfeiture. One gentleman said the cops broke into his house and stole a large sum of money. Another guy, I mean, okay, let's just boil all this down. You know, like every case is pretty much the same, but every case is different. That's a true statement. But take that letter about a simple question, okay? If you were to take that kind of principle in writing, instead of writing a document, right, where you just take all of these emotions and you dump them into and you ask 100 questions or 10 questions, real aggressively, and you're telling them, pointing the finger, you better not do this, you better not do that. I'm going to say two things. First, I want you to take yourself and put yourself in their position and pretend you're hanging out and somebody barges into the room and starts barking at you and telling you, you did this and you did that and you're evil and I can't believe you're the kind of guy that would do this and blah, 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 and they're just going off on you. Man, even if you're wrong, there's no way you're going to listen to that. You're going to tune that out, and it's going to shut down, and it's over. They're not going to answer you. You're not going to get anything out of that person. I've got a buddy who's going through some serious stuff with his wife, and it's hit that point where they're just, he's nervous about it, so he's constantly going to her, and there's this barrage of questions and things, and that's just going to destroy any hope of dialogue. So if you think about how you feel about that, even if you're wrong, even if they're wrong, what if you calmed it down and you just asked them one question, and then you ask them another question, and then over the course of a month, now you've got 4 or 5 questions in, and they never even saw the chess game you were playing because you were leading them, but you were so unaggressive, they just literally thought you were Mr. Nice Guy or didn't know what you were talking about. I literally called somebody, was it yesterday, JC, or the day before?
No, it was on Monday.
On Monday. And I got on there and acted a little bit like I didn't know what I was talking about. I mean, I literally just pretended like I was in sentence fragments and I was acting like I didn't really. And when he got so frustrated, he wanted to correct me. So by the end of the call, he told me exactly what we were wanting to hear, and I don't think he even caught that he did it. And so if you think about it, it's really the letters for them to read, but it's to protect you. It's to help you. So you want to be as sly as a serpent and gentle as a dove. Don't let them see. Be the hand up Mona Lisa's skirt. Don't let them know you're coming. Like you've got to just think about it simply, get the English down where the wording's proper, But you can take those principles and those letters and apply them to almost anything you're doing. Just ask someone, hey, what gives you the right to take that property? What gives you the authority to take that property? A person doesn't have a right, and they sure didn't author it, so they don't have the authority unless you gave consent, right? Because the government only can have power if you give it consent. So if they're taking things from you, okay, and you don't want them to, something's happened. You've either given them consent implied or expressed in some way. And the driver's license is a perfect example. You saw the benefit not to get clubbed in the head, not to be shot at, or not to go to jail by having a driver's license. And because you did that, you agreed to service a summons for 180 days, and they're gonna use it up and just beat you down until you just kind of cave in. So just think about the beauty and simplicity of one-sentence letters where you got the wording proper and you just step them right where you need them. That was it. Sorry, DC.
Yeah, and another thing, getting back to the service of summons, is that they do not always execute holding it for 180 days. If you are confident and you know what you are saying, and really fewer words say a lot more. The last time I was before the man in a robe, I probably said all of about 15 words, and he never got jurisdiction over me. He never signed an order, like a judgment order or a warrant, but he still locked me up for 48 hours. So it's still a dangerous game, and you got to know the stakes when you're going in. But if you know what you're talking about and you stand as man or stand as woman, then they will not be able to get jurisdiction over you. And if you pull that off really well the first 3 times you go in, more than likely they're just going to let you go. And they're going to find a reason not to deal with it because they know exactly what they're dealing with. And if you really, really know what you're doing, you can go back and get all of them on malicious prosecution. So, and I think it's interesting what they call a prosecutor. I actually call them a persecutor because most of what's going on in the courts these days is persecution, and that's basically using force to enforce somebody else to try to believe what you believe.
Well, they're still under the Inquisition, technically.
Yeah, that's going to happen when I get these documents to my senator and district attorney. What I did to others, I'm going to do to them.
Hey, Amy? Because you're just joining us on the show now, one of the first shows we did, and this could come in useful for you and the people you talk with. Somebody asked us basically how to move a common law claim in front of a jury, and the pretty simple answer is that whenever you go to file, go before the magistrate and have at least 2 other witnesses.
We don't have a magistrate that I know of.
Well, every courthouse has a magistrate. Like a magistrate's a judge, basically. Like all judges are magistrates.
I guess that was my mistake. I didn't go because I was told you're not going to win in reading that book, The Kangaroo Court. So I just
listen to what he's getting ready. Listen to what he's getting ready to tell you, and you're gonna hear. Okay, that's what this is for. Listen to what he's getting ready to say. It's monumental. Everybody else listening, this is the answer a lot of you guys have been looking for like 6-7 years. Some of you 30 years. Listen to what he's getting ready to say.
So if you can take 2 witnesses with you, and you guys can be very inventive, and I'll give you a hint here in just a minute, but if you have 3 people declare a fact upon the record, they have to put it in front of a jury to change that fact. I have
my medical doctor, my general who wrote character letters, who's known me since 2004. Those are 2 people right off the bat that are very high-level people. The VA.
Yeah, but listen to what he's saying. Listen to what he's saying, okay? Let him finish. It's not the way you think. Just listen.
So, Amy, let's just say we're talking about you. If you have a doctor and someone else who witness or know of firsthand facts that apply to that case, take them down with a suit, okay? You would be filing some type of action. Go down to the courthouse, require a magistrate to file the action. They have a magistrate on call 24/7. You can even do this at 2 in the morning down at the police station, okay?
Sheriff's Department, yeah.
Yeah, Sheriff's Department. And go in there, file the suit with the magistrate, and go ahead and have the other 2 witnesses have declarations, and also while you're in front of the magistrate, go ahead and swear your testimony upon the record. Okay. And once that testimony is sworn upon the record, the only way, if you have 3 different people swearing to the same set of facts, the only way that they can challenge that is with a trial by jury. That's it. So, and on the flip side of that coin, if you wish to hold people liable who are in government offices, you can do the same thing if they've actually committed a crime. You can have multiple witnesses go down and you write out your own criminal complaint. And when you're going in front of the magistrate, because whoever is the man or the woman affected, injured, or harmed, that's the only one who can actually swear out a warrant. And whenever they go in front of the magistrate for a complaint and swear out the warrant, also have 2 witnesses to go and swear to the same set of facts. And a way to get really creative with this, now that we have the age of digital audio and video, and I would suggest everybody keep some sort of recorder on their persons at all times.
I'll have secret recordings on that.
Yeah. So, like, we have very inventive ways of recording stuff. We can record stuff and nobody will know.
That's another reason why they'll take the car, because they don't want it on evidence, any kind of recording device.
And here's something else that's really important. Like I said at the beginning of the show about inform, conform, uniform, you guys got to quit using their documents. You cannot use their forms. If you do, then your belief you can never validate your belief, okay, with their stuff. Because if you're doing that, you're completely subjugating yourself, because you're putting them in the position of superiority, right?
Yes.
Okay, so you can't do that. So did you catch what he said about creating your own criminal complaint?
I do.
Yeah, you don't use their forms. You can make your own documents, guys. Summonses, complaints, declarations, all that stuff has to be your hand, the hand of man or woman.
Mm-hmm. And that's what I've done with my senator. That's how I got action immediately.
The last time I went and filed a criminal complaint against the Superior Court judge, when the magistrate came down, she asked me if I had filled out their form, and I said no, and I handed her my form, and she goes, okay, wait, let me check this for all of the qualifications real quick. They already knew me in that courthouse anyways. It was 2 sentences. That was the entire complaint, 2 sentences. And she goes, yep, this meets all of the standards. Let's go ahead and swear you in. And we got the testimony on the record right then. And so one of the ways to be inventive about this, with the age of audio, like digital audio and video recordings, is that if you can get a recording of it and you can get 2 people to come over and listen to that recording, they can go to court and say that they listened to the recording after you introduce the recording as evidence, and they can talk about not only what they see, hear, this, that, and the other, but the very big thing that most people forget is that when you are testifying, you can talk about how it makes you feel. You can testify to your emotions, and emotions are really, really cool to testify to because no one can ever, ever, ever come back and say that you were lying about testifying to your emotions.
As a matter of fact, a good attorney, when he's in front of a jury, will almost never argue the facts. They use emotion and sensationalism because that's often what will win a case.